Hello.
Hi, everyone.
Hi, everyone.
Hello, everyone.
Welcome, and thank you all for joining us today for a discussion on investigation and prosecution of children in a counterterrorism context. My name is Cecilia Polizzi. I am president and director of CRTG Working Group, which is an organization founded in 2018 with an aim to protect the rights and well-being of children at risk, victims, and survivors of terrorist recruitment and use. I am personally thrilled to be moderating this panel, which I think is going to be a very stimulating discussion of the ways in which both the investigation and prosecution of children in CT is to be carried out, and also working towards achieving our shared goal of enabling appropriate justice responses to children associated with violent extremist organizations. The issue of children recruited and used by terrorist actors has grown disproportionately in the past several years. In its contemporary dimension, the involvement of children in terrorism has emerged as a critical trend in both the tactics and strategy of violent extremist organizations in irregular warfare and more broadly to the advancement of their agenda. We have had, in fact, an opportunity to acknowledge its protraction to all Salafi jihadist franchises in the Middle East, the Horn of Africa, Asia, the Sahel, and also to recognize its identifiable manifestation across the entire ideological spectrum. Terrorist and violent extremist organizations recruit, use, and exploit children in a multitude of ways, including for the perpetration of severe acts of violence, including terrorism-related offenses under international law. The alleged involvement of children in terrorism and terrorism-related activities brings into consideration fundamental questions in relation to the legal frameworks, procedures, and also authorities that these children should be subjected to, and calls for appropriate and coordinated responses. Prior to introducing our distinguished panelists, please allow me to acknowledge the participation of Mr. Jamie Brown on behalf of the Counter-Terrorism Division of the Council of Europe, and of Ms. Safina Ahayeva, Child Protection Officer with UNICEF Uzbekistan. Jamie and Safina, it is indeed a special privilege and a pleasure to welcome you on behalf of CRTG Working Group to this discussion. Without any further ado, I will now turn to our first speaker, Mr. Emerson Cachon. Mr. Cachon joined the IIJ as a program manager in 2018, where he leads the Juvenile Justice Initiative. Prior to joining the IIJ, he worked as a legal advisor and program assistant with the US Department of Justice Office of Overseas Prosecutorial Development, Assistance and Training West Africa Regional Program, with a focus on Benin and Togo. Previously, Mr. Cachon was a legal advisor for the Millennium Challenge Account Benin, and prior to that, a junior legal advisor with Stewart Global Solution, working on legal and policy reforms. He holds a master's in business law and administration, as well as degrees in applied English linguistic, business law, and judicial career.
It's not letting me change my name in Zoom.
Yeah, once you put it in.
Emerson, thank you warmly for being with us today. It is my great privilege to welcome your remarks. The floor is yours.
Thank you very much, Cecilia, for this opportunity to share our views and perspectives on how to handle children, how investigators and prosecutors should handle children in a counterterrorism context. So briefly, we are going to talk about some primary consideration and go through specific there are a lot of aspects that practitioners, especially investigators and prosecutors, should consider when it comes to investigating or prosecuting or pressing charges against children allegedly involved in terrorist-related offenses. So we are going to cover just a couple of them, including age determination, the role of investigators and prosecutors when they're coming to contact with those children, some alternatives to pretrial detention, and the role of the prosecutors. And then we are going to complete with key recommendations. So as primary consideration, we need to say that the UN Security Council in its resolution 24/2017 of 2018 emphasized the need for a swift transfer of children to child protection authorities. This implies the establishment of standard operating procedure for the rapid handover of children associated or allegedly associated with all non-state armed groups, including those who committed acts of terrorism, to relevant civilian child protection actors. So the UN Security Council also emphasized that children who had been recruited in violation of applicable international law should be treated primarily as victims of violation. So one thing to consider here is the best interest of the child. This is key. And the best interest of the child should be the primary consideration, and which means that in all action concerning children, whether undertaken by public or private social welfare institution, court of law, administrative authorities, or legislative bodies, the best interest of the child should be a primary consideration here. So the best interest of the child is among the 4 principles of the CRC, or the UN Convention on the Right of the Child. This means that intervention should ensure that the well-being of the child and the full, that the child enjoy his or her well-being and the full and effective enjoyment of their right recognized under the CRC. So the CRC also recognizes that children deserve special safeguard, care, and legal protection. So here, children deserve special treatment because of their vulnerability due to age and incomplete development of their brain. So this brain region called the prefrontal cortex, somewhere here, which is responsible of executive function, is not fully developed in children, and this makes them unable to make reasonable and informed decisions. Therefore, their vulnerability. So another fact to consider is that the UN Committee on the Right of the Child also stressed that state parties should ensure that all children charged with offenses, regardless of the gravity or the context, are dealt with in terms of Articles 37 and 40 of the Convention, which means that every child alleged as accused of or recognized as having infringed the penal law should be treated with dignity and worth, and his or her arrest should, detention or imprisonment should only be carried out as a measure of last resort and for the shortest period of time. Another consideration, as I mentioned previously, is the rapid transfer of children in the hands of child protection authorities. So to help practitioners and states implement the provision of the resolution that I mentioned above of the UN Security Council, as well as the CRC and other international norms and standards on children affected by terrorism, the GCTF, meaning the Global Counter-Terrorism Forum, along with the IIJ, developed a set of 13 good practices. This set of 13 good practices are commonly called the GCTF Neuchâtel Memorandum on Good Practices for Juvenile Justice in a Counter-Terrorism Context, or commonly called Neuchâtel Memorandum. So the IIJ became a leader in promoting these good practices, and as a result of promoting these 13 good practices, the IIJ put together, developed the IIJ Juvenile Justice Note for Practitioners, a set of 5 practice guides, one each for investigators, prosecutors, defense counsel, judges, and detention official, as you can see on the screen, which I hold here also in my hands. So these guides actually provide guidance to those practitioners, especially those 5, including social worker and other special educators, depending on the system where we are, on how they should handle children while involved in or affected by terrorism while respecting their rights. So this document that we have launched recently in February is available on our website in Arabic, English, and French on the link that you can see. So we are going to cover a few principles developed in the note, which relates to the investigation and prosecution of children in a counter-terrorism context. The first one is age determination. What do we mean? First thing we need to clarify here is the minimum age of criminal responsibility. So this means the age below which the law determines that children do not have the capacity to infringe the criminal law. So children below the age of criminal responsibility at the time of the commission of an offense cannot be held responsible in criminal law proceedings as defined by international law and standards. They should be provided with assistance and services according to their needs. Practitioners should refer to that age when prosecuting, or if they want to investigate children according to how this age is defined in their domestic law. Secondly, children at or above the minimum age of criminal responsibility but are under 18, they can be charged if there is enough evidence, obviously. Even so, they should be treated in accordance with international juvenile justice standards. But if the age cannot be established, practitioners should give the child the benefit of the doubt. Therefore, the suspect will not be held criminally responsible. So here we're going to talk briefly about compliance with basic rights after arrest. So this rests upon investigators because they are the first who encounter first the child. May they be victims, witnesses, or alleged offender. So police should ensure that their first experience encounter with those children provide those children with security and inspire respect and confidence in the police. Only minimum force should be used in dealing with children on arrest. There should be no use of handcuffs or restraints unless it is necessary for the protection of others or the suspect himself or herself. So police should avoid any harm to the child, including the use of harsh languages or physical violence. Some key rights that police should be aware of in investigation of such children. The first one is the right to the presumption of innocence, which is the basic that all authorities should bear in mind. Second, the right to be notified of the charges, the right to remain silent. Actually, the child must tell the police his or her name and address and provide them with some information. But the law, the international law requires that they do not have to answer any other question. So the right to legal or appropriate representation, which is a challenge in many countries, including Africa, countries that we work with. So police should facilitate the appointment of a lawyer or a non-lawyer public defender for the child immediately after the child arrest to ensure that the child's statements are not taken under duress. So the right to the presence of a parent or legal guardian. That's why one of the things reflects that the law enforcement should have is to strive to find a parent and inform them of the arrest as soon as possible. So the right to full respect of privacy, the right to examine witnesses, the right to appeal to a higher authority as well. So children should not be detained alongside with adults. That's why in a procedure where children are involved with adults, it is highly advised to law enforcement officer to dissociate the procedure and focus on adult and file the case. I don't like to call it case of the children in a separate procedure. Another aspect to consider is alternatives to incarceration. There are several types of alternatives, but briefly, I'm going to touch upon two briefly. On the release of the child to a parent or to a family member or a guardian is an option, and also diversion is another option. Quick definition of what diversion is: it is a type of informal disposition of a criminal charge which involves the referral of individuals prior to adjudication of guilt to rehabilitative and restitution programs instead of traditional criminal prosecution. So diversion is based on the theory that while a child may have carried out actions that are against the law, it is more damaging to them to be deprived of their liberty, and they are more likely to reoffend if they are taken through the formal criminal justice system. So depending on the system, we have law enforcement assisted diversion, prosecutor-led diversion, and judge-led diversion. A few considerations for prosecutors when it comes to in prosecuting children affected by terrorism. One important thing is that before bringing charges, prosecutors should determine whether children have attained the minimum age for criminal responsibility under national law. Prosecutors should then make sure that a thorough investigation of a child age has been completed. And to this end, prosecutors should also consider asking investigators to discuss the suspected offender's age with family and community members, and why not social workers. So such verifications determine whether the suspect should be transferred to child protection authorities for family reunification, rehabilitation, or community reintegration, or if those charges should be treated by the judicial authorities. Another aspect is to consider all children recruited and exploited by violent extremists and terrorist groups as victims of violation of their basic rights. And I'm sure we're going to cover more later on in this briefing. Prosecutors should use caution in accepting confession of children suspected of accused or accused of committing terrorism offenses. They should not rely just on the child confessions as a basis for bringing criminal charges, including for terrorism or related offenses. So they should understand first the circumstances, the length the child has, the length of the child's initial detention, how the police and investigators treated the child, and the condition under which the child was interrogated. These are a lot of factors that can influence the way the child responds to investigators. So he or she, the prosecutor, should also use and promote alternative measures to pretrial detention for children in order to protect their rights. Key recommendation to conclude. It's important that practitioners or states focus on the creation of dedicated court jurisdiction for children in a counter-terrorism context, so that practitioners who are there have specialized training and can address in a better way the rights, the protection of the right of those children. The creation of dedicated units. Such units within the police should be trained on how to communicate with children, because not all law enforcement units know how to communicate with children. They are more used to, as we all know, violence and force. So the creation of transit and referral center or rehabilitation centers for children. This is to help the child. Such center will be used to receive children who are not prosecuted for terrorism-related offenses, where the child can benefit from psychosocial care and also vocational training, depending on the level of involvement of the child. Practitioners should increase their collaboration in order to work better. Prosecutors, juvenile judges, if we are in a civil law system, and also investigators, they should involve also social worker when it comes to the determination of the age of the child. The respect of the basic rights that we discussed earlier is a must. All practitioners, especially investigators, should be trained on child-sensitive investigation in order to provide the necessary care to children. Increased training on diversion for actors and also alternatives to prosecution and incarceration to avoid long pretrial detention and provide the best opportunity for children. Increased training on rehabilitation and reintegration so that state and practitioner can also comply with international law and standards. Thank you very much, and I look forward to discussing more. Over to you, Cecilia.
Thank you very much, Emerson, for this remarkable presentation. I would like to take an opportunity also to thank the Global Counterterrorism Forum, IIJ, and all who have contributed to the Neuchâtel Memorandum and the Juvenile Justice Practitioners Note, both of which have offered critical resources in guiding the work of policymakers and practitioners providing justice responses to children in CT. So thank you very much. And please now allow me to introduce to you our next speaker, Ms. Irina Urumova. Irina Urumova is a child protection, sexual and gender-based violence and victim witness protection expert. She has over 15 years of international professional experience providing technical assistance in the areas of child safeguarding, crimes against children, victims and witness support, sexual and gender-based violence, and the child-friendly procedures. Irina Urumova is the co-author of the IIJ Practitioners Note for Investigators. She currently serves as an international expert with the Council of Europe in Ukraine, training the national police on child investigative interviewing and child sexual exploitation and abuse in general. Irina also serves as a safeguarding compliance investigator with the International Special Commission on investigating the allegation arising from the work of SOS Children's Villages. She has worked in a variety of regions from Central Asia to Middle East to Eastern Europe. Irina is furthermore a rostered expert for Justice Rapid Responses and UNICEF Europe and Central Asia Regional Office. Irina, it is my great privilege to turn the floor over to you for your intervention. Thank you.
Thank you, Cecilia. Thank you, dear participants, dear colleagues. Let me start my presentation. Please allow me a minute to share the screen. Okay. Yeah, it should work now. Well, we will speak about since I worked with Emerson on the initiative that he mentioned, the practitioner's notes, I will further look into specific principles that Emerson has already mentioned. And well, I will start with a simple fact. I mean, in today's climate where violent radicalization of children and child recruitment by terrorist and violent extremist groups is more relevant than ever on counter-terrorism agenda, inevitably issues such as how do we handle children involved in such activities arise, and much of the discourse to date has focused on the dual status of children involved in terrorism-related offenses. So the need to primarily treat them as victims and to extend the full panoply of protections to children involved with the justice system in connection with their suspected involvement in the commission of terrorist or violent extremist offenses. Well, obviously, there is no denial that the best interest of the child should be a paramount consideration in all cases where a child is involved in a terrorism-related case. But how is this best done? Best interest of the child is such a fluid notion. It leaves so much room for interpretation that its application is never clear-cut. So one question is it sufficient to respond to children exploited by terrorist groups in full conformity with international standards on justice for children? Or does the sheer use of the word respond already imply that a certain critical watershed has been crossed and harm, perhaps irreparable, has been done? What can we do in this situation? Well, this is where investigators can step in to secure the important link between response and prevention. Proactive investigations not only help better protect society, but also better protect children involved or becoming involved in terrorism-related activities. I want to take a look with you at the IIJ practitioner's note for investigators, which stresses the effective engagement with local communities, effective engagement of police, and that of safeguarding the child's best interest in any investigation, including special investigative techniques and operations. Why is this important? We will discuss this in more detail in a minute. I also want to add that one of the recommendations emanating from the practitioner's note is to have in place appropriate protocols for extracting a child, especially one who may be in immediate danger, without exposing or otherwise compromising the ongoing investigation, which is a tall order, but this is one of the most important points. So, well, back to our importance of engagement with local communities. I want to link it with proactive investigations. Well, investigation in general help dismantle the generous preconception that harm must occur for action to take place. Not so. Certain evidence must be there, but we don't have to wait until the situation has deteriorated to a point where we're dealing with a completed offense. So timely following leads allows for dynamically detecting threats to children involved and apply requisite safeguarding measures to prevent further harm from occurring. And taking advantage of an imbalance of power or the child's vulnerabilities to coerce or manipulate a child into violent extremist activity is a form of child abuse, and it, as any kind of child abuse, requires early intervention to protect the young individual. In many cases, there is something that prosecutors can do in countries where, well, basically this kind of acts are criminalized in any, at least in the vast majority of states, and so where there is evidence to support prosecution for conspiracy or preparatory acts related to child recruitment. Children at risk of exploitation by terrorist and violent extremist groups may receive additional protection through this mechanism, which is a good thing. But sometimes it also comes a bit too late. And a big challenge here is to determine where that point is when an individual moves from extreme but non-violent speech to violent extremism. And some legislation on this glorification of terrorism have been criticized specifically for the vagueness of the concept that lie that form the basis of these laws. So this is all the more daunting when the individual in question is the child's parent or caregiver. And well, because obviously we also have additional factors here. It's, what is in the best interest of the child? Do we have to separate the child because it's not in their best interest to grow under the influence of someone who's increasingly violently radicalized? Or the prevailing consideration here should be the child's right to not separate from their parents. It's never easy, and it's, of course, case-by-case decision making is required. Another challenge in investigations, perhaps even more daunting, is that we're likely to face reluctant victims in many cases that involve children coerced or manipulated into violent extremism. This is not because children don't realize they're being victimized, but it's perhaps in a similar vein to children's involvement in criminal gangs. Some children, especially older children, because of the developmental factors that Emerson has mentioned, the prefrontal cortex underdevelopment. I'm not a neuroscientist, but obviously this not only prevents children from making rational decisions, but also makes them prone to risk-taking behavior, which pushes them to actively seek out engagement with various groups that break the law, including violent extremist groups. Another issue is, obviously participation in such groups is a form of risk-taking activity. The child may not want to cooperate. The investigator is obviously left with more limited options that do not rely on the child's support, but this also means that, and again, we go back to something that the previous presenter has mentioned, the need to protect the best interest of the child in any situation. This means extracting a child where the child is either already involved in terrorist activity or at risk of becoming increasingly involved. And this means that this child has to go somewhere. This child needs to, we are not extracting them into a vacuum. They need to receive support beyond mere isolation from the perpetrator and us safeguarding the child's physical safety. And this calls for a multi-sectoral approach, which really cannot be overemphasized. The focus on early detention and early intervention also means that we have to have a clear picture of the factors that put a child at risk for violent extremist engagement, as well as any red flags that should be followed up on. For instance, incidents of a child going missing or missing from education need to be thoroughly investigated. We don't know what is behind it. Of course, there may be short-term risks to such children's safety, but there may also be other risks depending on the situation, on the child's environment. And this is increasingly so in the case of older children and teenagers. We know that children are being manipulated in ways that are, very similar to manipulating children for other forms of exploitation, such as sexual exploitation. So children are groomed, and whenever a child goes missing or missing from education, we have to look at it very carefully to see, to assess the situation and to see if the child may be in danger and not. And in some cases, we cannot discard the danger of this specific type of involvement at all. And this means learning from good practices in investigating child exploitation in general. At this point, I'm arrived. Yeah, so I've already gone through this. We may want to consider some recommendations here. Well, something that is actually very, very obvious is to consider the best interest of the child throughout our exposure to children involved in terrorist or violent extremist activity. And this means also in proactive investigations. Also rely on the intelligence picture developed through proactive investigations to not only to build a picture of how the key offenders are moving behind the scene, but also to inform any possible safeguarding measures to be applied in respect of children encountered in the context of the investigation, which goes back to the need to extract a child without compromising the integrity of the investigation, the success of the investigation. And if you remember in the beginning, I mentioned the importance of involvement of with local communities to build such intelligence picture. Obviously, unless there is trust with local communities, getting such intelligence that can be converted into useful evidence is diminished. And finally, an important recommendation is to conduct criminological research to identify drivers of violent extremism and vulnerability factors that are specific to children, as well as red flag indicators. This is my, recommendation specifically for the police, but also for child protective agencies, for child protective authorities, because this also informs the type of programming that the child should be involved in order to be rehabilitated. But these are just recommendations, and there remain as many unknowns as there are knowns. And actually, this expert briefing is a perfect opportunity, a perfect forum for us to discuss any knowledge gaps there exist and exchange promising practices, which I'm sure the distinguished participants present here will have. And I would like to conclude on this note and pass on the floor to Cecilia for further discussion for us to ask and share. Thank you.
Thank you very much, Irina, for sharing these invaluable insights, for referring the importance of a child's best interest, early intervention, and also the diverse nuances of proactive investigation approaches. I would like now to turn over to the questions and answer period for this expert briefing by giving the floor to Pita Law, Phronesis Consulting and Training. Pita, the floor is yours. Thank you very much.
Thank you, Cecilia. Thank you, Emerson and Irina. That was excellent. It's lovely to see you both again. The first question that I would have for you is, thinking about your presentations, what are the particular relevant considerations for managing children and young people in a counter-terrorism context?
perhaps I will let Irina start. Irina?
Okay, fine. Yeah. Well, I will name a couple of considerations that, to me personally, they appear salient, and probably Emerson would like to complement the picture. Well, there is. We talked about the need to protect the child's best interest, but what is in the child's best interest were the child's parents or caregivers are the ones who are actually responsible for violently radicalizing the child, or the ones who are, well, maybe not primarily responsible, but if they are silent on this, if they are somehow encouraging this behavior, they refuse to see the obvious. I would say that's very problematic, because you know, deprivation of family environment is a serious issue. It's not something that has to be taken lightly, but at the same time, what do we do, or the child acts in contrary to the child's best interest? I would say this is a very tricky issue.
In addition to what Irina said, just one quick thought. One thing to consider is that government forces apprehend suspected children in many ways during security sweeps, military operations, screening procedures outside of camp for internally displaced people, and based on information provided by informants. So reports have shown that in many cases, authorities arrest children with little or no evidence. But according to international norms and standards, children shouldn't be kept for a long time in custody. The thumb rule here is to make sure that they are not kept in custody at all, because generally they are prosecuted with what we call involvement in a terrorist organization or in a non-state armed group. So then when they are apprehended, either generally by the military, depending on the region and on the context, when they are apprehended by the military or the police, they are kept in custody before pressing charges, before bringing the procedure in front of the prosecutor. So anyway, whether they are in military custody without charge, or they are charged and are in pretrial detention, for instance, children are entitled to lawyers at every stage of the procedure to ensure that their rights are protected and their voice are heard, and to ensure that the procedure is done in compliance with, let's say, international norms and standards. So in places where access to lawyers is difficult, and we've seen many of those places, state can put in place some measure to create what we call non-lawyer public defender. It sounds really weird, right? Non-lawyer, but these are people, they may be teachers in countries like we work with, like in Niger, for instance, in West Africa. These are people that are trained, they are teachers, they are civil servants who receive special training and can provide care, can assist children during police interviews, for instance. So another things to consider here, in cases when there is no strong evidence of parent or guardians' involvement in violent extremism or terrorism, measures should be taken to limit the interaction between them, because it is in the child's best interest not to be involved in the parent's ideology or illegal conduct. So the early involvement of the child's legal representative here is crucial and can reassure the child. This will also help collect information on the child's background, his relationship with the family or the community, and can be used in the investigation. So the child, appropriate legal representative, and all social welfare and social workers, they have the necessary training to explain to the child the reason behind the decision to keep them separated from their parent. So in cases when it is the child's behavior that causes problem here, rehabilitation and reintegration are key. They are the best option. So even in such cases, if the child is in custody, the link with parents should be kept. So detention officers and other officials in charge of the detention facility where the minor is detained should take all the necessary steps to ensure that the minor remain in contact with their parent through visits, phone calls, conversation, and any other means available. So one last thought, all personnel in charge of detention facility where the minor is detained should take unnecessary steps to ensure that the rights of the detained juvenile are upheld. So I will conclude with that and return you the floor, Peter or Cecilia. Thank you.
Well, actually, if you allow me, Cecilia, to just to add something to react to an interesting point that Emerson mentioned. Would you allow me?
Naturally, Irina, please
Yes.
go ahead.
Oh, just literally a couple of words. Emerson, thank you for mentioning the issue of detention and for respecting the child's rights, you know, in decision-making on detention, and if the decision is made to detain the child in basically while the child is in detention. But here, you know, we talk about minimizing detention on the one hand, resorting to it only when necessary. At the same time, we talk about the importance of treating the child primarily as a victim. But since, you know, we're talking about issues, we're talking about primary considerations, we're talking about challenges, I want to be a little bit of a devil's advocate here. What do we do where the state doesn't have developed witness and victim protection schemes? What do we do with children who are first at risk of ostracism and probably retaliation by their communities, who maybe, you know, if you return them to the community and the community is not happy about it, if the community treats the child as evil, what about children who risk retaliation at the hands of the violent groups that had recruited them? What do you do? I also would not be so squarely blaming the states that choose to detain such children because they're not doing it because they mean harm. They're doing this because they don't have better ways to protect these children, and perhaps assisting them through building more robust witness protection schemes, appropriately resourced. And honestly, I don't, in the entire region where I've worked, I don't know a single country where such a scheme would exist, like literally none. So I would say that I'm talking about the countries where I have worked, which are not, you know.
Irina, you raise a good point in terms of what is the right balance then between approaching children from this vulnerable victim versus rational actor kind of approach. Yeah. What do you think is the right balance between that? I mean, there are many young people who are victims of that circumstance, and then there are others who have been actors as well. And so there's this kind of crossover. They're not binary positions, are they, often for children and young people?
Actually, who do you give the floor to? I mean, I could say a couple of words about the rational actor versus victim.
Naturally, please, Irina, go ahead.
So essentially what I think is, by rational actor, if I understand, you want to move it a little bit into the sphere of rational choice theory, if I understand it correctly. So basically, it's about the capacity to make a rational choice. Well, does the child indeed have that capacity? capacity of the child is evolving, and it's never, well, in fact, even children who have reached the minimum age of criminal responsibility, they're still prone to making serious judgment errors. Same goes even for young adults. That's why some countries have those young offender categories for children who are, well, for young people who are above the age of 18, but under, I mean, sometimes 25, sometimes lower age, but they would be treated differently because it is a fact that their brains work differently, and there is still a way for them to develop to be fully able to reach rational decisions. If we talk about rational choice, we talk about criminal opportunities. How do you assess a criminal opportunity? What are the costs and what are the benefits? What the costs and the benefits for an adult, reasonably mentally stable individual are different from a teenager who may actually, for whom an added risk may be rather a factor pro than a con. They would say leaders, but a perpetrator in that case does not necessarily mean a rational actor, and this is why we have juvenile justice systems in the first place. So yeah, it's an interesting, almost philosophical question that you're asking, Peter. Thank you.
Thank you very much to the both of you, Irina and Emerson, for these brilliant responses. I would like now to give the floor to Mr. Jamie Brown.
Thank you, Cecilia. I just introduced myself for those of you who don't know. I'm Jamie Brown. I work in the Council of Europe in the Counter-Terrorism division. Thank you both, Irina and Emerson, for really interesting presentations on very difficult topic. If I can, I'd like to just zoom in a little bit on, and maybe there's a little bit of a follow-up on this question of rational choice, and kind of on this question of early responses and early interventions. Because early suggests certain paths or some form of predictability to activities, which might not necessarily be the same for younger children, teenagers, for all of the reasons outlined so far, as they would be for adults. So I'm just wondering, how do we then square that with kind of, early interventions, especially when those early interventions are themselves just by default taking place prior to the activation of minimum criminal responsibilities in a lot of circumstances. The second part of that would then be, because that's kind of an abstract question in some ways, how does this change the different roles of different interveners, different actors, police, social services, and others, for instance, in this context? I'd love to hear your thoughts on that. Thanks.
Cecilia, if you allow me.
Naturally, Irina, please go ahead.
So, well, a very good question. Thank you, Jamie. And again, this is my opinion, but I don't see any fundamental conflict between the need for the law enforcement to intervene and the well, basically the fact that a certain threshold has not been reached in purely criminal terms, because we're dealing with a child here. If we were dealing with an adult, I would say yes. It's a serious challenge. With a child, the state, above all, we don't see, I mean, juvenile justice is different from adult criminal justice in precisely this. The state bears the responsibility to safeguard the child, to make decisions on behalf of the child well, to decide what is in their best interest, which may not coincide with the child's personal opinion. Obviously, the child has the right to be heard, the child has the right to participate, but the authorities also, the judge, or depends on the stage of the proceedings, has the power to override those considerations if they believe that the totality of evidence points to the need for the intervention to better safeguard the interests of the child. And if the law enforcement can intervene in cases of child abuse, up to emergency removals, which are pretty drastic measures. And, you know, obviously, I'm not talking here about the procedural safeguard, the need of judicial control. This is beyond the topic. But the law enforcement is doing is fulfilling an incredibly, it's a critical function actually, because only the law enforcement has the powers to intervene, to basically isolate the child, extract the child from potentially seriously harmful circumstances in situations of imminent threat to the child. So if we see the child as a victim, the rationale for us to for law enforcement intervention at an early stage, I think becomes obvious. If we see the child as somehow a mini adult who has fair trial rights, but is a suspect, is a defendant, and is not a victim, regardless of the circumstances, which should not ideally be the case, then yes, the law enforcement should wait until a certain point. With seeing the child as a victim, I would say there is need for the law enforcement to intervene as early as possible, but obviously in collaboration, coordination with social services, child protection services, and various other actors whose primary responsibility is to you know, safeguard the interests of children in difficult circumstances.
May I weigh in a little bit here?
Of course, naturally.
Yeah, it's an interesting point, Jamie. I've seen there is in a law of one of the countries we're working with, Niger, they have provisions for such situations. They provide simply that in such cases, law enforcement officers or community leaders to provide information to the prosecutor, and the prosecutor can so Niger is a civil system. So the prosecutor will then refer. Again, refer. It's not a judicial process here. So we are not talking about due process and such. So can refer the case to the juvenile judge. And it's up to the juvenile judge to take the measures for the protection of this child who is in danger. Because here we are talking about a child in danger. And we'll refer the case to whatever actors are available. Refer the case, they will draft what we call an ordinance, an order. So an order for the protection of the child. Social workers and also available state entities who provide these services to this type of children who are in danger will then take it from there. And there is no case per se here. It is done, if you will, in a very civil way. So that's the brief addition I wanted to bring. Thanks.
Thank you so much to the both of you, Irina and Emerson, for these very, very comprehensive responses. And Irina, if you don't mind, I would like to go back for a minute on what you were mentioning before regarding the nuances and the balance of approaches of the victim-perpetrator dichotomy. And in this respect, if you allow me, I'd like to invite Florence Kayemba, who is the program manager of the Stakeholder Democracy Network in Nigeria, to take the floor. Florence, please. Thank you.
Thank you, Cecilia, and a very big thank you to our experts today. It was pretty much informative. My question is still related to the victim-perpetrator dichotomy, but I think I'm really talking about systems here. Obviously, you know, some of you might be familiar with our situation here in Nigeria, where you've got thousands of children who've either been recruited or who have left insurgent groups, but there are no real systems either for protection, for rehabilitation. So you have a lot of children who are still very much susceptible to being re-recruited. How do we deal with these sorts of situations? We've got a judicial system that does not necessarily get involved in the protection of children, because as you probably heard, you have found children also in prison with adults, especially northern part of Nigeria, for being suspected of being of aiding Boko Haram activities. And I mean, it is our reality. So I just wonder how
Florence, my apologies to you all for interrupting. Can you hear me well?
So all you're doing is that you're bringing back children back into
Florence, this is an excellent question, and also very, I mean, there need to be systems in place to, we can't really treat that on a case-by-case basis. I mean, some good interventions can be perhaps be piloted, but again, there needs to be political will. And unless it exists, I'm afraid we're left with a situation that's pretty much, at least I personally don't see a solution there, like with the political will being absent and some essential, I'm not talking about infrastructure and I'm not talking about perfect systems, but at least about the possibility for willing actors, be it local self-government bodies in cooperation with civil society institutions to put together some initiatives to rehabilitate those children. I know it has happened in countries like Kazakhstan, where there is no integrated national child protection system. They have some actually exemplary programming to help children in difficult circumstances and children in conflict with the law in particular. And they have been actually working on them even before their legislation was amended to create these possibilities. So basically, they used the loopholes in legislation to pilot diversion, to do all these things, but it means there was political will, at least. And yeah, I mean, if there is no, I'm not in a position to assess the case of Nigeria. I've never been or worked there. So basically, you are the one who's ultimately able to assess whether or not the situation is right, at least for piloting some things.
Thank you very much, Irina, for highlighting the critical need for effective juvenile justice responses, and also for referring to the pivotal role that nation state plays in this regard in enacting human rights and child rights compliant responses to children in terrorism. Thank you very much. I would like now to move forward in our question and answer session by inviting Safina Ahayeva to take the floor. Thank you, Safina.
Thank you, Cecilia. Good day, dear colleagues. I'm excited to be here, and many thanks to our keynote speakers for very interesting presentations. My question concerns diversion, because also Emerson mentioned in his presentation that diversion should be applied. This is recommendation. And indeed, if we refer to CRC, yes, deprivation of liberty is a measure of last resort, and diversion is a measure of first resort when desirable and appropriate. I'm wondering if there are good practices from other countries or maybe emerging evidence saying which diversionary measures are good, are effective for children involved in violent extremism and terrorism. Thank you.
Thank you very much, Safinas, for this brilliant question. And Irina, if you would like to start answering, and afterwards we will be giving the floor to Emerson for any follow-up. Thank you.
Thank you, Safinas. Thank you, Cecilia. Yes, I will first start with what is stopping many countries from actively use. I mean, even those countries that have diversion, I mean, where it exists in practice, and there are procedural provisions that allow it. Even those countries sometimes are reluctant in implementing it in the case of children. Child suspects in terrorist and violent extremist offenses because of the concern that this would somehow mean being too lenient on grave crime. And here I would like to share an interesting factoid. Well, there is some stats on children and terrorism in France that I was able to dig up that shows that actually, and this concerns years 2015, 2016, so it's relatively recent. So the overall number of children prosecuted for terrorism-related offenses more than doubled between these 2 years. But no child in that period, none at all, in 2015 or 2016, was convicted or prosecuted for attempted or actual terrorist attacks. Many were prosecuted for the offense of criminal conspiracy with a view to committing a terrorist act and for advocating terrorism. There is no precise stats on diversion, but since France does use diversion in respect of such children, it is quite possible that some of these children were diverted in practice. A far higher number of children in the same time period were under protective court orders because they were found to be at risk of violent radicalization that leads to terrorism because of family environment, because of other factors. And so, yeah, in that case, no prosecution took place altogether. And well, obviously, probably there was also no evidence to support prosecution, but the state took protective measures to ensure that the child does not, that further harm is not done to the child. There are some good practice. So what that means, in a nutshell, is that it's not a given that a child who is somehow involved in violent extremist activity is necessarily committing a grave crime. There may be cases where the child is advocating for terrorism is a notoriously fluid offense, and some of these children may have just been engaging in instances of speech that is not quite under free speech protections, but does not necessarily warrant the application of basically prosecuting the child, processing them through the criminal justice system, convicting them if found guilty, etc. Considering specific examples of diversion, of diversionary practices, well, there are some cases from the Netherlands. There is a program called HALT, which is, in general, it's for children, for it's not specifically developed for children at risk of violent radicalization, but it has also been used in their respect. Perhaps you would like to read up on that. In Netherlands holds an extremely multidisciplinary approach to managing such children's cases. There is a national coordinator on security and counter-terrorism at the national level, but individual cases are discussed at municipal level, and individual tailored plans of action are developed for individual children. Perhaps, I mean, if you're interested, perhaps I could dig up more information on that and share it with you if and others who might be interested if such a need arises. But yes, there are some good practices from the EU at least.
Thank you very much, Irina, for this wonderful response. I would like now to give an opportunity to Emerson to take the floor should he have any further comments.
Sure, thank you. Irina touched upon some important points here. It's very important that practitioners assess what is the level of implication of the suspect in the alleged offense, right? So being suspected of involvement in a violent extremist group or a terrorist group doesn't make a child a terrorist or a violent extremist group. Even this sentence that I just said, if some actors were here, they'll be like, never say that again. Yeah, but right. So one thing to consider here, those children, when we take the case of Nigeria, for instance, there are many are adopted, right? And go through harsh conditions. Many, especially girls, unfortunately, are raped, and some of them even get pregnant. And we've seen some cases when these children really no longer want to live, right? So they went through harsh conditions, and when they are in the hands of apprehended by the military or law enforcement officers, so they're in a situation of trauma, and diversion here comes here to serve as a way to kind of escape further trauma. What I mean by further trauma, detention. If government officials detain them, that's an additional trauma for them. And that's why some practitioners or researchers talk about double victimization here. So we don't want to end up in that situation. That's why diversion is here to help them get rid of this to address emotional trauma and the stigmatization that often occurs when minors are prosecuted in the child justice system. So yeah, a few important things, consideration aspect before we talk about the best or some promising practices in terms of diversion here. Depending on the state, diversion can happen at many levels. As I said, at the community level, there is diversion, and this happened in the Philippines. At the police level, at the prosecutorial level, and then in front of the court. Another aspect to consider here is that diversion is not automatically for everyone. Diversion is for first-time offenders, not recidivist or second-time offender. Diversion will help here the child to kind of amend if there is evidence that a crime is committed again. So if there is no evidence, yes, depending on the country, we may talk of diversion, we may call that diversion, or it may not be called actual diversion, but transferred to child protection actors. In any event, when we take the case of, let me share very briefly the case of the Philippines. Diversion is applied only to children who are above 50 and above 15. So 15 and below 18 years old. And another consideration here is to prove that they acted with discernment. A third consideration, the offense should be committed, should be an offense bearing a penalty of 12 years or below. So from one system to another, there are a lot of consideration to see here. And when we still look at the case of the Philippines, before even diversion is provided, and in all countries, the child should agree with the plan. Otherwise, there is no diversion. And one important aspect specific to the Philippines is the recommendation of the social welfare officer. They recommend the specific type of diversion that corresponds to the needs of those of the child. So the social worker task here is very important. The report and the report he or she will provide the social worker is key in order to identify, to determine what type of response should be provided to the children. Another example here, and here we're talking about practices that we know. I will use again Niger. Niger has created what they call Transit and Referral Center. So in French, that is CTO, Transit and Referral Center. It is a center, a kind of a rehabilitative center created to receive children affected by terrorism-related activities. So affected, they are not necessarily prosecuted. Those who are affected as victims or witnesses, or there are cases where, okay, one of the cases that come to my mind, a child who was about to be sold to a terrorist group across the border of Niger and Nigeria. So the father was about to sell his child, his boy, to a terrorist group, to a man for something. So in such case, those children, when they are in the hand of the police to protect them, they go through the system, the judicial system, but they benefit from the protection of the law. Then they are sent to this center, which is the Transit and Referral Center. And here they receive training, rehabilitation, and they also receive some vocational skills, psychosocial support as well. And at the end of their stay in the center, they should draft per se, if they don't know how to draft, there is a social worker who help them to put together a life project, like when they will leave the center, what they will do as activity. And also, depending on the type of the offenses of in which the children had been found with, there are special educators who are provided to the center to assist the children understand Quran, for instance. Community leaders also can provide a specific training. So all these are some examples of measures, diversion measures that are put in place in the Transit and Referral Center. And we have seen cases of children who return back to the community after they have successfully completed their term and found ready to be returned to the community. They were returned successfully and they started their life project. So this is my addition to what Irina just mentioned. Thank you.
Thank you very much, Emerson, and that was of great value to this conversation. Thank you so much for providing further insights into strategies to approach handling of children in counterterrorism, and also particularly the ones that can be in fact recommended to nation state. Thank you warmly. I would like now, in the next segment of this Q&A, bring your attention to the phenomenon of foreign terrorist fighters, which of course, as we all know, has been a priority on the political agenda of both the European Union and member states in the past 5 years. In fact, since the inception of the Syrian crisis, thousands of EU nationals have traveled or attempted to travel in conflict zones in Syria, Iraq, with an intent to join terrorist organizations such as the Islamic State of Iraq and the Levant and other insurgent groups. We acknowledge that the condition of children of foreign terrorist fighters who were brought by their parents to Syria, Iraq, or who have born to foreign terrorist fighters' family in the region continues to remain particularly concerning. And the EU member states and other countries around the world continue to experience a set of unprecedented challenges concerning legal, ethical, and practical questions with respect to their obligation and capabilities of handling children of foreign terrorist fighters who are still abroad, and also those who are already on EU soil. And in this regard, I would like now to give the floor to Peter Allo for questions. Thank you, Peter.
Thank you, Cecilia. Yes, I'd like to ask Emerson and Irina, what are your thoughts on how should the repatriation of these children be managed? So what are some of the best practice principles and maybe some examples of where this is being managed really well?
Thank you, Irina. If you would like to answer this question, thank you.
Well, thank you for the question, Peter. It's quite a global question. I will speak about what I know, and perhaps Emerson would like to complement from his perspective. As I've already mentioned, I worked in Central Asia a lot, and one of the countries that was the first to start a repatriation scheme was Kazakhstan, and actually I think their experience is quite good. First off, they really pay attention to the balance between safety, security, and the child's long-term best interest. So what they do is they repatriate families or a child with an accompanying adult, one of the parents or a guardian. Some of the children were born abroad, which means, you know, there is need for procuring documentation, etc., which I will not touch upon. But what happens to them first, they're housed in temporary reception centers that are tightly, I mean, they have a very high level of security. All the vetting, security vetting of the parents, all the preliminary investigative interviews with the parents that are, you know, basically will be subject to prosecution, in whose regard there is evidence to support their prosecution, are conducted on the premises of these temporary reception centers. But there are psychologists, there are social workers who provide services to the individuals accommodated in the centers. So it's they start receiving therapy from day one, literally. And if the decision is made to separate the parent and the child, the parent is taken to a detention center. The child is never taken to a detention center. The child is always housed in the community, usually with an extended family. Or if there are two parents and only one is prosecuted with the parent who's able to return to community. And in community, again, they're subject to police monitoring. They're subject to monitoring by social services. So basically, there is a balance between security needs, social needs. The children are not separated from community. The children attend regular schools. There have been some concerns about how communities would receive those children. Apparently, it's not that bad. There have been some cases where the children were kind of shunned, but no bullying, at least not that I know, no like major incidents. Basically, people are getting used to that, and they start seeing those children as just, you know, unfortunate, you know, people who are not necessarily, who don't necessarily share the same values as the ones who are responsible for their, you know, being taken away from the country or born in a conflict zone. And so basically, and the psychological and social services to these children in the community are provided by a thoroughly vetted, outsourced civil society center. And actually they were the ones, it's the same center that piloted diversion in Kazakhstan in general. They were the pioneers. They've been in business, so to say, for quite a long time. So they're quite good, really. And they are the ones who, I mean, there are also others appearing, but also the quality of the civil society actor. They're not random organizations who simply happen to win an award. You know, they are the ones who have worked with various categories of children, including delinquent children, including child offenders, well, basically children in conflict with the law. And well, so far, so good.
Thank you very much, Irina, for offering such a comprehensive overview of those that are considered best practices in handling the child returnee contingent, and also for touching upon the influence that parents or caregivers may have upon a child, a particular child, the radicalization process and compounding risks. We are now approaching the end of this expert briefing. I would like to extend a sincere thanks to the both of you, Irina and Emerson, for your remarkable presentations, as well as this Q&A session, which I must say to have personally found an extremely enlightening discussion. I would also like to thank IIJ and the Counter-Terrorism Division of the Council of Europe for associating with us on this event. Thank you warmly to Ms. Safina Ahayeva, Child Protection Officer for UNICEF Uzbekistan, for her crucial work in advancing the state of justice for children in contact with the law, and for her agile inputs to this session. And the same is true for Pita Law, who has been a long-time collaborator of IIJ and is also a cherished colleague in CRTG working group, and whose role has been nothing but pivotal to the organization of this event. And thank you very much to all of our member representatives for joining us and listening attentively. And I look very much forward to our continued engagement.
Thank you.
Thank you.
Thank you. Goodbye.
Thank you, Sia.